one of the main reasons why people smartly hire lawyers, why it's a good idea to hire a lawyer, is because it is personal to you. If you've been injured in a car accident, you've been injured one way or another, and you want to receive compensation for your injury, that's a personal thing to you. That could affect the rest of your life. You're going to understandably be emotional about it. You hire the lawyer to help you mitigate that. You hire the lawyer to be the go-between, so your presentation, so your claim is not motivated primarily by the emotion. It can be done more professionally.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You are listening to Law Have Mercy. So today's guest, very excited, good friend of mine, my homie, came in all the way from Baton Rouge today after sitting in traffic on I-10. Chase Tettleton. He is a trial lawyer. He does plaintiff's work and defense work with Babcock Injury Lawyers. What's up, Chase?
What's up, Chaz? How are you today?
I'm good, man. Thanks for coming in.
Thank you for having me.
I think it's really cool to Chase and I actually lived together in law school.
Different rooms.
Different rooms, and we're not going to tell any of those stories today. That'll be
totally off limits.
That's going to be the Law Have Mercy After Hours podcast. That's coming out soon, right? We may need a different designation for that one. What you think, Carter?
Yeah, put the explicit on it now.
Yeah, well, we're going to have to put all the explicit warnings on it and maybe just create a whole new name for it, and might have to put you in a mask. Who knows?
I like the mask idea.
So Chase, you've been practicing, what, 13 years?
13 years. Same place, doing more or less the same thing, and the whole time it's all litigation, all trial work, and like you said, it's a mix of both plaintiff and defense.
And that has to give you some unique perspective when you're handling a plaintiff's case versus a defense case, right?
I like to think so. I think, again, I don't know that it's a completely unique practice mix, but I do think the volume that we handle, that I handle personally, on both sides kind of gives me some insights into what the other side is dealing with right now, because I've been there myself.
Yeah, I don't get to have a beer with insurance adjusters, and so I don't really see what their pain points are other than what I see their response to me.
Right.
You actually know from their side what they're looking for.
That's correct. It helps me when I'm representing someone who's been injured to understand what needs to be shown, what the adjuster or the insurance company wants to see, and B, how they want it to be displayed to them, the format that they want it in. And I think that's helped me represent folks as best I can.
But because you're a trial lawyer, a lot of things, cases are settled just at the adjuster level before you even get involved.
Definitely.
And so when you get involved, there's some type of issue. And I'm talking about when you do defense work.
Right.
There's some type of problem with the case that the adjuster is looking at.
Right.
Can you describe some of those things that are a reason for the lawyer filing suit where you actually have to defend it?
Sure. I mean, typically the cases that end up in my lap as a defense attorney either involve a significant dispute over who's at fault, a significant dispute over whether this accident caused these injuries, or just a big disagreement over how much the injuries may be worth in terms of value. So those are kind of the three main disputes. Sometimes the case may have all three, but usually that's why it's gotten there.
And sometimes they just may be against the 1 year time limit and have to file suit, right?
I see that a lot, and really it's you hit that 1 year mark, you come up to it, and it's for whatever reason not ready to be settled. So they file the suit, and then they come to an agreement with the insurance company to continue to try and work it out. It's only when that's not proceeded, I guess the attempt to negotiate fails, that's when they send it to me.
And how do you, when you're dealing with lawyers, having been on the other side and you're constantly on the other side as a plaintiff lawyer too, does that help you in dealing with plaintiff lawyers?
For sure. Because I represent plaintiffs and I understand what an injured person is dealing with, in the terms of their personal life away from the case. It helps me understand when I'm dealing with an attorney on the other side. I understand what or at least I have an idea of what their relationship is with their client and what the problems the client's facing, and sometimes it explains why they may be reaching out after a long weekend to find out if we can settle this case, that kind of thing. I know what's going on.
I think what you get after 13 years of experience, because you and I graduated together, so I've been practicing law 13 years too. I think one thing that hit several years ago is I realized that it's not personal,
For sure.
right? So although you have a client that's injured, and that is very a personal thing, and you've developed a relationship with these clients, and you empathize with them, and you understand them, and you feel bad for them, there's still a level of professionalism that you have to have when dealing with another attorney on the other side.
And I think even before that, dealing with an insurance representative, one of the main reasons why people smartly hire lawyers, why it's a good idea to hire a lawyer, is because it is personal to you. If you've been injured in a car accident, you've been injured one way or another, and you want to receive compensation for your injury, that's a personal thing to you. That could affect the rest of your life. You're going to understandably be emotional about it. You hire the lawyer to help you mitigate that. You hire the lawyer to be the go-between, so your presentation, so your claim is not motivated primarily by the emotion. It can be done more professionally.
And not only is that person qualified, obviously,
Right.
by having a license, but they're more objective in how they represent you because they're not so emotional,
Right.
because they weren't the person actually injured.
If you have a lawyer who matches your level of emotion about a case, that's a problem. That's when you see a runaway situation where things get out of control. That becomes the case becomes about everything but the injury. It becomes about the fight between the lawyers, or the animosity towards the insurance adjuster, or something like that. That's all detrimental to reaching the end of a case, which is a conclusion, whether it's through a settlement or at a trial with a verdict from a jury or judge.
Some people have the misconception, and I think it's probably from TV or something, that they want a very emotional bulldog lawyer that's going to fight for them, and I think some of that is a facade as well, or just some marketing that they do. But can you explain how that might not be their most effective representation?
Right. Look, I see it all the time. I see lawyers who approach cases with a degree of aggression that maybe isn't warranted by the case, to put it mildly. But that may just be, sorry about that, the kind of aggressive tactic, that may just be how they approach the world. It may not just be their professional life. It may just be their personality. And so it may work for them. But more often than not, when you're responding to an attorney who is the bulldog, the kind of typical, stereotypical bulldog type lawyer, they don't know when to pick a battle, it seems, and everything is a fight. And what does that do? That delays the resolution of a claim. It increases the cost of the claim. It just makes it less likely that the injured person is going to get to their desired outcome quickly.
I always thought that I did a good job of choosing my battles. Mm-hmm. And when I worked at the public defender's office, I learned, because we'd hire a lot of new lawyers, and some of them would come from different states, and they felt that they were coming here on some mission.
Yep.
And if they weren't fighting for blood, they weren't doing their job.
Right.
But sitting back and observing, I found that sometimes those tactics had the opposite effect.
It's often completely counterproductive. It is the opposite of the steps that move a case forward. If I'm fighting with you over the language in a medical authorization, and if I'm having to go to court and fight you back and forth, that doesn't do anything towards moving the case forward. Sometimes there's going to be a dispute, and sometimes we're not going to agree, and sometimes we're going to have to go to court and argue about this disagreement. But we should do our best to limit those disagreements when we can. And again, this is not a professionalism conversation per se, but when it comes to selecting a lawyer, those are the kind of things that are going to stand in the way of getting to the end of a case. It's the extraneous fights, the unnecessary fights.
Because if I pick an unnecessary fight with you, then you could pick an unnecessary fight with me,
Right.
and make my life more difficult.
Right. One of my favorite, I think we always find ourselves as lawyers asking the other guy for an extension. Hey, I need another week. I know the deadline's tomorrow, but I've got a family obligation, so I kind of get another week. And it's those experiences when that request is denied that usually indicate to me we've got a bulldog, and this is going to be a lot of wasted effort in this case.
Are you ever surprised at the types of cases that plaintiff lawyers will actually accept and move forward?
I'm surprised daily. No,
Do tell, please.
Yeah, no, it surprises me, not the case itself, not the underlying accident, the injury. It surprises me why these particular cases have arrived in a litigation posture. Why is there a lawsuit filed over this? Why wasn't this settled earlier? There's a million reasons why it wasn't, but there's always one culprit, and it's usually the lawyer.
I was in a podcast with a med-mal lawyer, and he said that, first of all, 90% of the cases, the phone calls, they don't even get past the initial phone call.
Right.
5% after that, they do some due diligence and then decline it. And I asked him, is rejecting a case a good thing for the client? And he said it's one of the best things we can do for the client is have an honest conversation with them and say, you do not have a case, and here's why. I'm sorry, but it closes that chapter in the book for them, and they can move on from that instead of dragging them through litigation for 2 or 3 years.
Right. A medical malpractice kind of case is, in my opinion, a little bit different than a car accident case. Most people don't have any intuitive sense of whether a medical error happened or not. They need to rely on the doctors. They need to rely on the experts. But just through our lived experience driving around, you know that other guy was at fault for this wreck, or you think he was. And so even if you were at fault and you think you're not, if you call me, I owe it to you to explain to you at least my take on the situation. I think you're right. A lot of folks just decline the case. They may cut it out. They may decide this is not what I want to move forward with, and they don't explain it to the client that's coming in the door. I think they owe that. I really do.
And sometimes, we're doing a service by telling them why it's not worth pursuing, and they may not like that answer and talk to another lawyer.
I always encourage folks, when I tell them I can't take their case for one reason or another, I say, don't take my word for it. Go talk to somebody else. There may be a smarter lawyer that sees something where I didn't. There may be somebody who knows more about this situation than I do. I encourage it.
And when you're on the defense side, sometimes you realize the lawyer should have had that conversation with their client, but didn't, and now everybody's in a bind. There's money owed, there's bills, there's work that's been put into it. But
the train has left the station, and the only way once you've filed this suit, once you've gone down this path on a case that you probably should have settled long before the lawsuit was filed, you've, like you said, because of the expenses, because of just the practical realities of filing a lawsuit, now you've limited your options. And now you may be forced to go forward all the way to a trial in a case that you really don't want to. But for lack of preparation, lack of communication, poor expectation setting, maybe not being honest with the client, I guess that road goes both ways. But if you,
or the client, in other words, or the client not being honest with the lawyer about how many wrecks they have been in the past, or that how hard the impact was, or their medical treatment or their drug usage or any of those things.
That's right. All of those factors are, how honest you are, what you tell your lawyer at every stage of the case, from the initial phone call when you're talking about the wreck that happened yesterday to the conversation you had the day before you walk into the courtroom for trial. If the lawyer doesn't know something It doesn't know the full truth. When it inevitably comes out, it's always going to hit the hardest and most detrimental to any kind of case you have, whatever that case is.
So to have a good personal injury case, I always say you need three elements, right? You got to have liability.
Mm-hmm.
Somebody else has to be at fault. You have to have damages, some type of injury, right? And that can be your actual injury, the medical bills, your pain and suffering, time away from work, some type of definable damages.
Right.
And number three, you have to have insurance.
Someone's got to pay.
Someone has to pay, and we don't like the likelihood of collecting on a person without insurance.
Well, there's a reason why they didn't have insurance. It's not because they were flush with cash. The folks, I had to look this up to update my understanding. According to 2019 numbers, 11.7% of drivers in Louisiana are uninsured. It's actually down. It's improved from the last time they did the study, 2015 or so. It's a lot better than our neighbors in Mississippi. They're 25% of the motorists on the road in Mississippi are uninsured.
So one out of four drivers is rolling around with no insurance.
When you drive to Destin, hold your breath when you pass through Mississippi.
Or have a lot of uninsured motorist coverage.
Have it all, yes. I know that you're a big proponent of the UM coverage.
I am.
I echo that. I also encourage
For good reason, right?
Every single person I talk to that will indulge me on the topic of insurance, I sell uninsured motorists to them.
And okay, so 11% of drivers have no insurance.
Right.
How many have just the minimum?
In 2015, it was half of the remaining in Louisiana had the minimum, right about half. I didn't see those numbers updated, but I'm assuming it's about the same.
So can we say between 50 and 60% of Louisiana drivers have either no insurance or just the minimum?
That sounds about right.
And I get a lot of medical records. I get a lot of medical invoices. Emergency room visits keep on rising and rising and rising in the costs.
Absolutely.
An ambulance ride is $1,500 minimum, and I'm looking at emergency room visits of $3,000. I used to say $1,500, now it's $3,000.
That's right.
Because you have a ER physician bill, you have the hospital bill, and you may have a radiologist bill.
And if you go in the emergency room after an accident with a headache, they're going to do CT scans. It's probably going to be a $20,000 bill.
And so $15,000, which is the minimum coverage that people have if they have insurance,
Right.
is gone before you even get started.
Gone in a heartbeat.
So you have to have uninsured motorist coverage to stack on top of that to protect you.
Got to have it.
I have been on a kick lately where I'm telling people, if you don't have some type of traumatic event, some type of traumatic injury, head injury, broken bone, a fear of internal bleeding, go to the walk-in clinic instead of an emergency room.
Absolutely. If you're not bleeding, and if you're able, I think, again, everybody, you have a pretty good sense of your own body. If you feel like I may not make it through the night, go to the emergency room. If you feel like I am very sore, I want to make sure that I'm okay, maybe get x-rayed, go to the urgent care. It's cheaper, faster. You're going to get out of there without incurring a lot of expense and wasting a lot of your time potentially. Have you been to a hospital emergency room lately? It's not the most fun place.
And I'm going to ask, because I'm going to ask directly from the horse's mouth. If I have a neck and back injury type case, which we see most often because that happens to be the injury that's most associated with car wrecks, right?
It's the most fragile part of your anatomy that's usually impacted by an accident.
Which is most vulnerable, right?
I think the way the doctors say it is that it's the neck and back are the parts of your anatomy that are most subject to rapid deceleration.
And so, well put. All right, so put your defense lawyer hat on. I'm going to put my plaintiff lawyer hat on. If I am making a claim against your client and I chose to go to the urgent care versus the emergency room after the accident, the day of, the next day, the following day, are you valuing my case less?
No. I'm just not doing it. Not for traditional, the neck and back kind of soreness that most people experience after a wreck. If that's your complaint, if that's the situation you're dealing with and you feel like you need medical care, I don't see any value, I don't see any difference in value in an emergency room visit versus an urgent care visit. The value is really what happens after that first visit.
The only difference is I'm going to have about $3,000 more in my pocket because I'm not going to have to pay those bills.
That's right. Or put it another way, you're not going to have to worry about how to pay $3,000 more for bill. They're going to get paid one way or another, right? The hospital is going to pursue collections. They do it, Baton Rouge, they do it here. So you have, if you don't have health insurance, God forbid, and you go to the hospital and you get a big bill, they may come after you. You're better off if that bill is lower, if everything goes bad, if the other driver doesn't have insurance and you didn't listen to Mr. Roberts and get uninsured motorist coverage, then you're going to get stuck with a bill. You want that bill to be reasonable if you can.
Chase, I'll do you one better. There are people that go back to the emergency room. Have you seen that?
They go to different emergency rooms even. And I think that is a symptom of our probably larger healthcare system more than anything else.
Well, they don't have a relationship with a doctor, I guess.
That's right.
And so they've just understood that you go to emergency room whenever you need medical treatment.
Right. That's the best access they have. Again, I don't think that people do that strategically. I think that people do it because they don't have a better option. And that's what they know to do, so that's what they do because they're hurting. And I think the people that are going to the emergency room multiple times in the first couple of weeks after an accident, they're probably really hurting, and they need, those are the kind of people that need the help of a lawyer that can guide them to the appropriate care, help them find the right sort of treatment to address their injuries that you're not going to find in the ER. The ER is going to plug you if you got a hole that's bleeding, or they're going to mend a bone and then send you out the door. They're not there to treat your injuries from a car accident.
No, in fact, they're going to diagnose you with a neck sprain or a back sprain and send you on your way.
Yes.
And that could be a multiple herniated disc. It could be a back or neck surgery candidate down the road, but they're going to diagnose it as a sprain or a strain.
If you can walk out of there, you're just fine to them.
Because they have more pressing needs.
They have actual emergent matters.
And the other issue with that initial treatment is even people that do have a family doctor, sometimes they'll go to the office and the doctor will say, and this is not a knock on family doctors. I love my doctor, and I'm sure you love yours. They play a very vital role, but they'll say, "Were you involved in a wreck? I'm sorry, I can't treat you."
Right.
Why is that, Chase?
I think especially a family practice doctor, just an internal medicine doctor that you see for your colds and things like that, they don't have the office infrastructure to prepare the kind of medical records, the kind of complicated, complex, comprehensive medical records that are usually needed when a case is involved or when there's a treatment that's involved in some sort of litigated case. So they just want to avoid it if they can. And it's probably for the best because in my experience, really, the family doctor, again, they're sort of a lower intensity emergency room. They're there to make sure that your medical conditions are appropriate. If you need any kind of specialized care like you need after an accident, if you're suffering from a neck or back injury, go to the neck or back experts.
Yeah, and I think another issue, like you said, the infrastructure, but they have to see 30, 40, 50 people a day.
Right.
They're getting squeezed by insurance companies. They work on volume practices.
Right.
So the thought of stopping their practice and giving a deposition for 3 hours and taking a morning off would be crippling to their business.
Right.
Or a full day in court.
And I think that the same applies to almost any specialty, really, but because they have, again, the office infrastructure, they've got the staffing, they've got the partners, they've got it built into their process that X number of days are going to have to be devoted towards the legal side of things. They're better set for. That's why you're just better off going there.
And how
Again,
much?
not a knock on family practice doctors. They've got a role. I just don't think it's in a traditional accident case. The role isn't as important as the specialist roles are.
And how much does it cost to pay for one of these specialists to give a deposition or appear in trial?
If you can find one for less than $1,500, I'd be surprised.
That's a bargain, man.
That's a bargain. typically it's about $2,000 just to pay them for their time to show up and testify about the treatment that they've done. So yeah, there's some expenses down the road. Hopefully that's after a suit's been filed and all those other, I guess, qualifiers have been met. You've got liability, you've got the insurance, you've got the damages. So now it makes sense to spend that money. If, early on in the case, again, we're talking about limiting your expenses, not going to the hospital. I think that's a smart time to do it.
Yeah, and I see doctors' bills of $5,000, $10,000 to testify. Yep. And so, as we were saying earlier, when you take a case all the way into trial, once the train leaves the station, you better believe in the case and it has merit, because you have to pay a physician one way or the other.
I had involved in a trial 2 years ago now, or 3 years ago, but pre-COVID. We had 2 surgeries performed on our client. He had a knee surgery and he had a neck surgery. And that required 2 separate specialists, 2 separate surgeons. They both came to testify live at trial. One was paid $10,000 in advance and one was paid $15,000 in advance just to come testify at trial. They each testified maybe 30 to 40 minutes on the stand about their treatment. We won. It was okay. We got the money back, but those are hard checks to write.
Very hard checks to write. So, because of the 3 elements, right? The insurance. If you're involved, if it has enough merit, we have a pretty good idea of the insurance early on. So, the fights are really in the liability,
right? And
that's who's at fault.
Right.
Tell me some of the situations where you're fighting that fight, where when the plaintiff thinks it happened this way and your client on the defense side thinks it happened a different way. Where is that? How could 2 smart lawyers get it so differently?
Well, because their clients have 2 different memories of what happened. The classic example are red lights. I mean, they see that all the time. People are involved in an accident in the middle of an intersection that has traffic lights. Someone's going to say they had a red light, or everyone's going to say they had a green light. And so now it becomes a fight over, well, who didn't have the green light? So those are almost impossible to sort out unless you have independent witnesses and you have dash cam video, external video, things like that. The other kind of disputed liability cases that I often see are lane change rear end type accidents, something on the interstate in traffic or approaching a traffic signal. Someone's changing lanes and someone's hitting the other car from behind, and there's always a dispute over how long you were in that lane or how it exactly happened. That's where you really can see a lot of differences of opinion.
Do you recommend a person get a dash cam?
Yes. I only hesitate because I don't have one myself, and I want to say absolutely. I think it's probably completely it's overdue that they be in every vehicle sold. I don't understand why they're not at this point. I think it's a great idea.
I think it does 3 things. I think a dash cam, well, one, it can help prove that you were not at fault.
Sure.
Right? And if you rear end another vehicle, the only way you have of proving that you were not at fault is with a dash cam.
That's right.
Because the rear-ending vehicle is always presumed to be at fault.
That's correct.
Failure to maintain a proper lookout, following too close, something to that effect. But you and I know that there's situations where someone stops short for no reason, doesn't put on their blinker. Something happened that caused the rear end.
The worst kinds of cases to get involved in on either side, the most difficult to bring to a conclusion through a settlement, are he said, she said kind of cases that rely on 2 different completely irreconcilable versions of what happened, because everybody gets entrenched in their version, their position. And what you have with the cameras, you have this independent third unblinking eye that tells us what the actual truth is. And so we don't have to worry about what your memory was or what her memory was. We get to see the video and we get to decide what actually happened.
The second reason I think dash cams are important is it could potentially prevent road rage incidents.
For sure.
I don't know if you've given that some thought, but it happens, right?
Well, I think it tends to probably, I haven't driven in a car with a dash cam, but I could imagine that it makes you a better driver knowing that there is a camera rolling that's documenting what you're doing. It's almost like the body cam effect on police. That is one of the prime reasons why body cams are pervasive now, is because it has a tendency to make the law enforcement behave better, because now they know that there's video out there.
I use the example of the camera in a grocery store, right? Preventing theft. You know you're being watched, so you got to be a little bit more careful. That could prevent road rage type incidents, but also I think knowing that you are being recorded, and if you are wrong, you will have definitive evidence that you were wrong,
Right.
would make you think twice about texting and driving or being distracted or whatever.
If you have a dash cam and you are involved in an accident, my recommendation is don't let the other driver know you have a dash cam. Hold that information till the law enforcement officer responds, let them know, but only after they've talked to the other driver.
I also think taking pictures, and especially in the he said, she said, taking pictures but also videos.
Yep.
So I've had lots of cases where the other driver has admitted fault, and 10, 15, 20 minutes later when the police officer arrives, they change their story.
Right.
And then the witnesses that were sticking around have to pick up little Johnny at softball practice, baseball practice, whatever,
Right.
and they leave.
That's right.
If you had a video camera, you do have one on your phone, and you start videoing the scene, videoing any confession,
Yep.
videoing witnesses. Hey, you got to run. Would you mind giving me a quick statement? What's your name? What's your phone number? What'd you see?
What's your address?
What's your address? There's another one. Name, number, address. What did you see?
That's right.
And then now you have some proof.
That's right. And if you can record the other driver in the moment where they are inclined to confess to their fault, if you can get them to confess on camera, that's fantastic, because you're right. 15 minutes later, when they've returned to the cab of the truck and their adrenaline's now declining and they realize, I'm going to lose my job over this, that's when they start changing their position.
So those all go into the liability section, right? Who is at fault?
Right.
And in Louisiana, you don't even have to be 100% at fault. You can be 50% at fault. You could be 20% at fault and still recover.
That's right.
Right? Because it's a comparative negligence state.
That's correct.
Or comparative fault state. But that's not your only battle as a plaintiff or a defendant. Right. You also have to get to the damages. Right. What are some of the disagreements on actual damages?
Well, it's an element of damage. I would call it medical causation, really. So if you have an injured person who has been involved in several other accidents in the past 5 years or so and is injured in those accidents, the question becomes, what was the injury before this wreck happened versus what's the injury now? What can we attribute to this wreck? Because the at-fault driver, even though they're at fault, they are only at fault for what they caused. If someone already needed a back surgery and they're involved in a wreck and they have the back surgery, well, there's obviously a question of what the relationship is between the wreck and that surgery. And that's often the source of a lot of big fights. Yeah,
that's a causation, right?
Medical causation.
And we hate using those lawyer terms, but it's causation. We are responsible for what we have caused in this wreck. And very rarely do we find someone that has never been injured or never been in a car wreck before, because they just live life, right? Mm-hmm. And what people don't understand is that once you file a lawsuit and the other side is entitled to all of your medical records from the past 10, 15 years, whatever. Anytime you got a massage and you talked about neck pain and back pain, that could be used against you.
When you went to the massage parlor and filled out the one-page form and they asked the box, have you ever had neck pain? And you're going to check yes. Have you ever had back pain? You're going to check yes. Because you want the massage therapist to work on those parts of your body. In 3 years in the future, when you're involved in a lawsuit over an accident that severely injured your neck, you can better well bet that that's going to come up in the case, and someone's going to ask you, about why you checked that box yes 3 years ago.
And it's okay that you had neck pain and back pain before. And we can talk about it. That's why it's so important to disclose that to your attorney to the best of your recollection, right? You can't remember every massage you went to, every chiropractic visit you went to. But if you disclose, this is the best of my ability, or maybe I had neck pain, what you don't want to do is say no.
Right.
Because if you say no, and it's an absolute statement like that, if the defense lawyer can show that you did have neck or back pain at one point, then it kind of kills your credibility. Is that kind of what
That's it.
is that where it goes to? It's a credibility call?
I can remember from way back when doing SAT prep, and they would warn you, look out for always and never, because it's seldom always or never. And so if someone asks you, have you ever had neck pain before? Maybe. I don't remember. Did you have neck pain in the past week before this accident? No. That's the difference. Injured people that have had neck pain in the past or back pain in the past, they can hurt their back or neck in an accident today. That can happen. What becomes an issue really is if they were still actively treating, going to pain management, and having procedures done when the wreck happened. That's a big problem. That's a big confusing problem.
And some people don't even disclose to their lawyer that they're currently taking pain medications for a prior neck or back surgery. That's insane to me.
I take a lot of depositions of plaintiffs who have been involved in accidents, so I get to ask them about their injuries and about their medical history. And I get to be in the room a lot of times when the plaintiff's lawyer finds out for the first time that their client was already in treatment for neck or back injuries. It's
maybe even from another wreck.
it's a special moment to see when that happens in person, because the look on the face is always priceless.
Maybe I've been in those conversations. Maybe I've been in those depositions.
It happens.
You haven't been practicing law. You don't have enough cases if some haven't happened, right? I mean, that comes with the territory. Something
I see being on both sides of the fence, I can see the stereotypes that each side has of the other. There are plaintiffs, there are people that are injured that will tell you that the insurance company is the devil, that they're the worst people on earth. They want nothing more than to screw out little people as much as they can. And you have insurance representatives that think that every person involved in an accident is a liar. No one's hurt. They're exaggerating everything. And those are sort of the polar ends of this thing. I don't think that that's true. I don't think that's the case. I don't think even when I catch a plaintiff red-handed, being dishonest about their medical history, I'm reluctant to think that they did that on purpose. I think that a lot of people just forget. I think that they have bad memories. Now, is it going to hurt their case? Absolutely. The case you're in trouble now, because it's going to be hard to ever get out from under that. But I don't know that I don't think it happens commonly or often that people intentionally lie.
What do you think is the top three? I'm putting you on the spot. What are the top three case killers?
On a personal injury side?
Yes.
Well, number one is not going to the doctor. One way or another, for one reason or another, you don't pursue the treatment that you need. Number two, you're dishonest about your past, like we talked about. And you don't disclose fully whether it's injuries, treatment, or arrest, things like that. And lastly, it's having unreasonable expectations, and not really understanding and taking to heart what the case is about, where you're going with it.
Getting back to what was your first one? Your first one was not going to doctor's appointments.
That's right.
Okay, so what that means is you didn't make your health a priority.
That's right.
So how can you convince an insurance adjuster first,
right,
and then later on down the road, if necessary, a judge or a jury, that you were really hurt if you did not make your medical treatment a priority?
You're involved in a wreck today. If you don't seek any kind of medical treatment for your injuries for 2 months, when you ask the insurance company down the road to compensate you for your injuries, they're going to ask you, well, what took so long? And you may have great reasons. There may be a lot of things going on in your life, whatever it may be. There's a million reasons why it may take that long.
You want me to give them to you?
But you're going to have to, you put yourself in a disadvantage by having to explain that.
Yeah.
And that is going to forever color that case in a negative light.
It's not fatal, but it's certainly not in a position to succeed.
If you, the same way if you have large gaps in your treatment, you're going to physical therapy and then you don't go for a month and a half, that's going to come up. Someone's going to ask you what happened. And again, there may be fantastic reasons for it. There are probably a lot of good reasons when something like that happens. But if remember, the insurance representative is looking at a bill and they're seeing a gap. They are not privy to what was going on. They are not there to know that you were dealing with a sick family member and you had to go take care of them, or
You were dealing with some other health issue that you had a cancer scare
that's
or
right.
something like
Your
that.
son broke his leg and you became the full-time caregiver. So, that kind of stuff happens.
But you're playing defense at that point.
That's right. That's right. And I also see a lot of times people don't pursue the treatment that their doctors recommend for them. So, example, you go to a chiropractor and the chiropractor says, I want to see you 3 times a week for the next month. And you go once every 3 weeks instead. That's not helpful. That's not the kind of consistent medical care that you would expect of someone who is injured in a way that
I'm going to play devil's
that
advocate.
you're representing.
But Chase, most people go to the doctor and they get some recommendations and then they wait 6 months before they ever follow up on that blood test that was ordered, and they felt better that day and they missed their appointment, and it's no big deal. Why is that different in personal injury?
It is no big deal in the grand scheme of things. It's a big deal when you are trying to support and claim for monetary compensation from a particular injury. And the less rigorously you pursue the treatment that's been recommended for your improvement, the less serious you appear to be about your improvement. And it causes all kind of questions to come to light about, well, were you really hurt in the first place? Was it really as bad as you were making it out to be? It's worth something, but it's not worth what you think it is, that kind of thing.
And this is a real lawyer term, but duty to mitigate damages.
Right.
So the best example I can have is hurricane comes through, blows off half your shingles. You have a duty under law to go put a blue tarp on top to prevent your whole house from being flooded.
That's right.
Because the insurance company can say, well, if you'd have just taken reasonable measures by putting a blue tarp on your roof, your house wouldn't be flooded.
That's right.
We owe you for the roof, but we don't owe you for a full-scale flood of your whole house.
Right.
By not going to your doctor's appointments, you are not getting better soon enough, and you are not mitigating your damages, which is your responsibility under law.
The big element in almost every personal injury case is pain and suffering. You want to be compensated for the pain and suffering that you experience because of the other guy's fault. If you go to trial, if you take the case all the way to the end and you're standing in front of a judge or jury and you're saying, I've been experiencing pain and suffering for 3 years, but you never went to the therapist that the doctor told you to go to, you never had the injections they wanted you to have, that everyone agrees would have made your pain and suffering better, then you should not be entitled to recover that long-term pain and suffering because you didn't do what you should have done to reduce those damages. You could have done these reasonable things.
You talked about being honest about your past, okay? And I think you covered pretty well why that's a problem when you lie about your prior injuries. But what about arrests and convictions? What does that have to do with anything?
Well, it's important to know, first of all, it's important to tell your lawyer about all of that. You should have a full, open communication with your attorney from the beginning. When the question comes up about a criminal history, the lawyer needs to know everything. The rules of evidence in this state and in federal law allow certain prior convictions to be admissible in court down the road to question your credibility. If you're a convicted felon, for example, that can be used against you in the sense of this guy's a felon, don't believe what he says. It's not very effective in my experience. People with criminal histories, with an isolated criminal background, it doesn't damage the case the way they imagine it will. What damages the case is lying about the prior conviction or lying about those issues. Then the focus is no longer on the crime you committed in 2013. It's now focused on the lie that you did last week. And that's a more difficult hole to dig out of.
If he's lying about that,
Imagine what else.
Imagine what else. And it's a simple lie because it's probably it's more embarrassing than anything, or they think that by disclosing that it kills their claim. But the reality is there's such a narrow window that any of that evidence could come into play, and the judge will probably still not allow that evidence into play unless you lie about it.
That's right. And one of my favorite responses is, have you been arrested? Yeah. What for? I don't know. What do you mean you don't know? Everybody knows why they were arrested. Now, you may have said, I didn't do it.
Or you may not know the exact name for it, but
yeah,
I took something. I mean,
yeah.
Drugs.
Yeah,
right.
It is. That is always, when I ask that question, I get that kind of response. That is a massive red flag to me. There's something here.
Right.
Or if you say, I've been arrested, how many times? I can't remember. It's, you can't remember how many times you've been arrested? Oh, my gosh.
Chase, do you think that surveillance is a case killer?
Well, it can be, and it can be a spectacular case killer.
Any war stories?
I've seen pictures or video of people pushing classic cars up ramps. I've seen pictures of people doing yard work when they have told the doctors that they're treating them, that they're unable to stand up. I've seen people, being very active with their family on video, which contradicts kind of what they represented their condition to be.
I always heard that Mardi Gras was in Louisiana, New Orleans especially, was always a big surveillance.
People can't help themselves.
Honey hole.
That's right. I've also, honestly, more often than not, when I see surveillance video, it is a nothing burger. Because as it turns out, most people are telling the truth. Yeah. Most people are honest about their limitations. And given the opportunity, they will tell you what their real true limitations are.
Because surveillance doesn't show pain.
No.
And surveillance doesn't show that they had to spend the next week in bed. And so that's why we warn our people. We don't warn them about surveillance because we want them to act hurt or act a different way. But they need to know, and the same as social media, that a snapshot doesn't tell the full story, but it could seriously undermine their claim.
I think it's more important with social media, to be honest with you. The number of cases where an insurance company or a business who's faced with a claim that will actually go spend the money for in-person surveillance, that's rare. That really is. It's not a common situation.
It has to be a big claim.
Got to be a big claim involving big money, and they have to have some concern very early on that there's a reason why they want to take this expense.
Because private investigators are very expensive.
Very expensive.
And it takes a lot of time. It takes a lot of time to follow someone to get the goods.
Right.
They're not there in the first hour getting the great footage.
Right. And on the other hand, social media is the opposite. On social media, you don't have to follow people around to see if they do something stupid. They do it right in front of you.
They're posting it.
Oh, it's crazy. There's.
If you find a way to warn people about social media that is better than what I'm doing, because I talk about it, I write, I sign, I do everything possible. I post videos on social media, not to post stuff on social media.
Yep.
People cannot help themselves.
They want to be open. That's the culture we're in today. It's to express everything that you're feeling, everything that you're thinking for public consumption.
And it's always the best moment of our lives.
Right.
Right?
Right. And everyone has a facade that when they're on social media, whether it's a curated TikTok account where they've got millions of followers, or grandma's Facebook account, grandma may be telling you the bad things that are going on in her life on Facebook. That's possible. But most people are, like you said, giving you only the positives. Everything's great. Everything's hunky-dory. And if I'm an insurance company representative, and on the one hand, you're saying, I'm so injured, I no longer enjoy life. And on the other hand, you're posting these Facebook posts about how great everything is. There's a disconnect that they're going to want to ask you about. And again, it's not to say that that can kill your case, though it can. You just have to be cognizant of it when you're doing it. You have to imagine, is what I'm saying here going to have a consequence beyond what I anticipate it's going to have?
So Chase, from the initial wreck to the point where the lawyer gets the file, what could a person do to absolutely kill their case?
Number one, don't call the police. If you are involved in an accident on a public road and you don't call the police, you are at a disadvantage for several reasons. One, you don't really know who that other person is. You don't have full confidence that they've identified themselves to you, and that's going to matter down the road. Number two, you don't know who their insurance company is. You don't have an a police officer's somewhat independent view of the scene, and you don't have confirmation that the accident happened. Those are the four things that I think are important in a police report, and that's why I recommend anyone who's involved in any kind of accident, call the police. Even if you got to wait an hour, even if you have somewhere to be, you need to figure it out.
If it's a priority to you, or maybe a priority to you, you need a police report.
That's right.
There's valuable information.
Got to have it.
Are you aware that in New Orleans, the police weren't even responding at times and not preparing police reports?
I'm aware that they have done everything they can in New Orleans to remove the obligation to investigate accidents from the police because A, they weren't doing a very good job when they did it, and B, because you couldn't get a report from them when they did come out to the scene. My understanding is that they are still responsible for it down there, and they just don't do a good job at it.
And I guess another thing that you shouldn't do if you want to kill your case, I don't know if that's a negative or what, but not get medical treatment as soon as possible.
Right. If you are injured, if you feel like you have some sort of symptom or pain from the accident that didn't exist before the accident, get it checked out. Most insurance companies, if you call them and talk to them, they will tell you, go get checked out. There's a reason for that. There's a reason they want to offer you some money today plus the bill. That's the idea, but that's neither here nor there. Go get the medical treatment you need immediately. Don't delay on that. The other thing I see people do often is they say they talk to the insurance adjusters. And again, representing insurance companies, I understand why people do it. The adjuster wants to move their case forward. They want to move they want to check the next box on their list, and that's oftentimes talking to the claimant. And more often than not, you're going to say something during that phone call that is either misheard or comes out the wrong way that you're going to have to contend with down the road. I see it all the time, and it's often just a slip of the tongue. It's often just a mistake that becomes impossible to correct.
Because what you say can and will be used against you.
Always. Something that always comes up are passengers in the car, who was in the car. God forbid you get that wrong during that phone call. God forbid you forget that your cousin was in the back seat that day, because now that's not going to match what the police report says, and now you got things to answer.
Red flags.
Red flags. That's what it is. And so I don't personally. I will allow my injury clients to give controlled statements to an insurance company if they need it, if they can articulate a good reason for it. That's something that I'm involved in. I'm on the phone with them. I'm in the room with them, and I would discourage people from giving a statement before they've spoken to a lawyer.
So, real quick, get a police report, get medical treatment as soon as possible, and don't talk to an insurance adjuster, and call a lawyer.
Call a lawyer.
Chase, thank you so much, man. Where can people find you?
We got a website, StephenBabcock.com, STEPHEN, Babcock.com. All my contacts on there. We've got Facebook. We don't have TikTok yet. We're coming for you, Chaz.
It's coming. It's coming. All right, I'll throw it in the show notes. Chase, thank you so much, man. Appreciate you.
Thanks, brother.
Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.